Mr. President.
Senator from Arizona.
Mr. President, let me speak just a moment about this act. The sponsors, as you've just heard, and supporters like Senator Portman have proceeded here with very good intentions. As you've just heard, a compelling case for finding ways to help people who have made a mistake or more have an opportunity to turn their life around. One of the reasons that I'm concerned about the legislation is that all of the kinds of programs that have been spoken of here to enable people to learn new skills or change their attitudes about life so that they won't commit crimes again, we won't have more recidivism. One of the concerns is that there's nothing to prohibit any of these programs from being done today, and they're being done all over the country, in state prisons, in federal prisons, and the like. The concern I have is that the effort to provide rewards for people to participate in these programs may have more negative than positive effects, and I think the sponsors of the bill need to look at that in order to persuade some of us that that these rewards are necessary in addition to the programs which are already in existence. The other thing that concerns me is that there's a forgotten person in this whole equation, and that's the victim of the crime. Ever since I came to the Senate, I have worked on legislation to support crime victims. And finally, and I think it was my first term in the Senate here, Senator Feinstein and I were successful in getting enacted and signed into law the Federal Crime Victims' Rights Bill. This act provides a whole series of rights for victims of crime, starting with the right to be notified of key events during the criminal justice process, and at appropriate times, the right to speak or to participate. Now, as I said, the crime victim seems to be forgotten in this legislation, which has the good intention of preventing recidivism, but one of the incentives for people to participate in programs while they're still in prison is that they can earn in effect, some credits to enable them to get out earlier or to go on other kinds of programs before they're released by participating in these programs. But the victims don't have to be notified. And with many of the people that are involved here and that have been in prison for a long time, there are reasons for the victims to be concerned about their impending release. Not to notify the victims, I think, would be a grave injustice. And so one of the amendments that Senator Kennedy and Senator Cotton have proposed is to provide notification. Now, some have said, well, this is redundant because the Crime Victims' Rights Act already requires notification. Yes, the Crime Victims' Rights Act requires notification of court proceedings, but not the kind of proceedings that are embodied in the legislation. Here, the proceedings are before the prison warden, in effect. He or she is the person who makes the decision, adding these credits up, in effect, to determine whether or not the prisoner is eligible for some kind of early release program. But the Crime Victims' Rights Act provides, and I'll quote it here in case folks are interested, provides that the victims have the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding. So first of all, it has to be public, and secondly, it has to be in court. That's not the proceeding that we're talking about in this legislation. And that's why the amendment of Senator Cotton and Senator Edwards is necessary, to ensure that in this context as well, crime victims are notified of the potential release of the perpetrator of the crime upon them, so that if they wish, they can allow their views to be known, presumably in some kind of written correspondence to the warden, which the warden could then take into account or not. Now, I heard a very odd argument made earlier on the floor here in opposition to this amendment, and it was that under the Crime Victims Act, about 10% of the crime victims don't care to be notified, and in effect, they opt out of the notice procedure. And therefore, because of that, there shouldn't be a notice requirement for this procedure. Well, that's a non sequitur if I've ever heard one. There are people who undoubtedly choose to ignore the notice that they've received. For whatever reason, they don't want to go back into the court or to do anything about the notice they've received. But for the other 90%, this is a very meaningful proposition. And I think it would be a very scary proposition for some people not to be notified that the perpetrator of the crime against them is about to be released, and they don't know about it, let alone have any opportunity to say anything about it. So the fact that 10% of the people may choose to ignore this notice is no reason not to provide the notice. If you don't want to receive the notice, there's something real easy you can do with it. You just put it in the wastebasket. Or if you're concerned that maybe you'll get notified again and that's a bother to you, you can let the warden know that you don't care to receive any more notices. This is not a very persuasive argument to me that because 1 in 10 choose not to do anything with the notice, therefore we shouldn't give notice to the other 90% for whom it may be extraordinarily meaningful. So to my colleagues, I would just say, remember that the only reason people are in prison is because they have committed a crime against someone. And that someone is frequently ignored in the criminal justice process. They shouldn't be ignored anymore. And at least in federal court, we have provided by law a series of requirements for notification and in some cases the right to be heard that finally recognizes that the victim should have some right to participate in and at a minimum be notified of the proceedings that involve a case that's only there because they've had a crime committed against them. And in many cases, it's a very meaningful thing for them to come to closure and to find a sense of justice in our criminal justice system, to be able to participate in that very same system. In the past, we seem to kind of gotten away from this. It's like it's the prosecutor and it's the defendant and nobody else has any reason to be involved. And yet, of course, the victims have every reason to be involved. So, to my colleagues who say, well, it's redundant, no, it's clearly not redundant. The Federal Crime Victims' Rights Act will not provide a remedy in the case of the bill before us. So if you care about crime victims, if you believe that they should have a right to be informed and to potentially present their view to the warden if they choose to do so, then I would urge you to support this amendment of the Cotton and John Edwards amendment. And finally, Mr. President, I heard an argument that, well, there is a victims' rights group, I've forgotten the name of it, that opposes this. I don't know that victims' rights group. I do know this. I have been in touch with a lot of the advocates for crime victims, and they oppose the underlying legislation. And one of the reasons is because it doesn't account for the rights of crime victims. Perhaps the proponents could get a little more support for their legislation if they would pay attention to the people against whom the crime was committed in the first instance, and at least notify them that the prisoner is going to be released and give them an opportunity to respond if they choose to do so. I urge my colleagues to support the Crime Victims' Rights Amendment to the underlying bill. I yield the floor, Mr. President.